On January 13, 2010, Robert Khuzami, director of the SEC's Division of Enforcement, announced several new initiatives aimed at identifying large-scale fraud cases early on by fostering cooperation by individuals and companies. This new approach seeks to make the SEC more proactive and enable earlier detection of fraud. These new initiatives, which Khuzami referred to as game changers, specifically identify the benefits that will be offered for substantial assistance early on in an investigation. What is most significant about these changes is that these formal guidelines mirror the standards for cooperation used by the Department of Justice and rely upon the tools most commonly used by federal prosecutors in white-collar fraud cases: cooperation agreements, deferred prosecution agreements, and non-prosecution agreements. These agreements were not previously offered in SEC cases in such a formalized manner. While cooperation was always important to the SEC, there was not the structure and certainty of these formal standards. Khuzami described them as follows. First, cooperation agreements are formal written agreements in which the Enforcement Division agrees to recommend to the Commission that a cooperator receive credit for providing substantial assistance, such as full and truthful information and testimony. If the agreement is violated, the staff may recommend an enforcement action to the Commission against the individual or company without any limitation. Second, deferred prosecution agreements, similar to what has been offered to companies investigated by DOJ over the last few years. For these, the Commission agrees to forego an enforcement action against a cooperator if the individual or company agrees, among other things, to cooperate fully and truthfully and to comply with express prohibitions and undertakings during a specified period of probation. If the agreement is violated during the period of deferred prosecution, the staff may recommend an enforcement action to the Commission against the individual or company without limitation for the original misconduct as well as any additional misconduct. Third, non-prosecution agreements. These are in which the Commission agrees not to pursue an enforcement action against a cooperator if the individual or company agrees, among other things, to cooperate fully and truthfully and comply with the express undertakings. Importantly, the enforcement manual notes that the latter two types of agreements require, quote, an admission or an agreement not to contest the relevant facts underlying the alleged offense. This language contradicts the typical prior resolution where the company or individual did not admit or deny the allegations as part of the agreement. The new manual sets forth the factors used to measure cooperation of both individuals and companies. With regard to individuals, the factors are 1, the assistance provided by the cooperating individual, 2, the importance of the underlying matter in which the individual cooperated, 3, the societal interest in ensuring the individual is held accountable for his or her misconduct, and 4, the appropriateness of cooperation credit based upon the risk profile of the cooperating individual. With regard to companies, the new and expanded enforcement manual formalized the factors previously set forth in the 2001 Seaboard Report. Specifically, the SEC announced that a company would be credited for cooperation through 1, self-policing prior to the discovery of the misconduct, 2, self-reporting, 3, remediation and discipline following disclosure, and 4, cooperation with and full disclosure to the SEC. Another important change at the SEC concerned a streamlined process for submitting witness immunity requests to the Department of Justice. Now the Enforcement Division, without seeking Commission approval, will be able to seek immunity requests from DOJ. This streamlined approach is important for the SEC to get information out of cooperating witnesses quicker, and is important for defense lawyers who want to cut a deal early on that will protect the individual cooperator from any potential criminal exposure. While the impact of the Enforcement Division's changes will take some time to be fully realized, lawyers who handle SEC and white-collar fraud investigations should be aware of the following practical considerations. First, the full benefits of cooperation will be reserved for what is commonly referred to as the first through the door. Early cooperation, especially prior to the initiation of a formal investigation, will be viewed most favorably and will be rewarded with immunity or non-prosecution agreements, whereas later cooperators may not receive any benefit for their cooperation. Second, the SEC is reserving this benefit for first-time offenders. Prior SEC investigations will likely preclude any deferred or non-pros agreement. Third, agreements with the staff of the Enforcement Division still ultimately require Commission approval, and ultimately may not have any effect upon the federal prosecutors investigating the criminal side. Individuals or entities under the microscope of both the SEC and the Department of Justice will have to negotiate and enter into separate proffer and cooperation agreements with each, although the standards and requirements appear to be nearly identical. It is important to note that the agreements reached with the SEC lawyers are not, repeat, not binding on the Department of Justice. Prosecutors working cases together with SEC lawyers will likely honor the agreements, but are under no obligation to do so. Finally, these agreements may create risks for cooperators in parallel civil litigation filed by private plaintiffs in that, as noted earlier, the SEC may require admissions of guilt, and it may be difficult to keep those admissions out of the later civil proceedings. Counsel should be prepared to confront civil enforcement actions in the same manner as they do Department of Justice criminal investigations. A civil litigator should understand the potential criminal consequences of any SEC investigation, and similarly, a criminal defense lawyer should understand the potential civil liability issues arising from a DOJ and SEC investigation. With a former federal prosecutor at the helm of the Enforcement Division of SEC, counsel and corporate clients should appreciate the fact that the traditional wall between criminal and civil enforcement of white-collar fraud investigations barely exists anymore.